Hey there, Kelly Longtin from Kelly Longtin Law, and today I want to talk to all of you about selling a deceased loved one's real estate and the things that you need to know when it comes to that. After a death of a loved one, such as a parent, there's a variety of tasks that must be handled to wrap up your loved one's final affairs. Now, selling your deceased loved one's real estate is one of the more daunting tasks. But before you call a real estate agent, you should take some time to get familiar with and consider a few of the key issues as you work through this process. The first thing to consider is who owns the property. And that's the first task that you need to understand, is who in fact is the legal owner of that property. Now, many families are surprised to learn that their family member was not the legal owner of the house where the relative had lived for years. Perhaps the family member was renting all along, or maybe they own the home jointly with another relative or a friend. So how do you find out whether your loved one was the actual owner? Well, first you must locate and examine the last vesting deed for that property. Now, vesting means that the ownership has become genuine and legal. The deed, the legal document that creates ownership of the property, contains the information needed to determine who the owner of the land was. When someone takes title to the property, the previous owner signs a deed. Then that deed is recorded with the Registry of Deeds. And the registry keeps track of ownership. And in most cases, the deed must be recorded before that property will vest in the new owner. If you can't find a copy of the recorded deed among your loved one's important papers, you may need to go to the city or the registry, or you can even look online for the registry, or you can call the attorney that they might have worked with, who can get you a copy of the deed. Those deeds are public record, and once you find it, it will determine whether or not your loved one had actually owned that property. Now, I want to talk to you about some things that you have to look for when you're trying to figure out the type of legal ownership that was on the deed. Now, each type of ownership has different legal implications. So understanding the differences is crucial, and you should get help where you need it in order for you to be able to make the necessary steps to sell or transfer the ownership of the property. So I want to talk to you about types of ownership, what to look for in the deed, who the grantee is, and then the possible next steps. So in front of you, you see the type of ownership when it's owned by a trust. What you'll see in the deed is, for example, Jane Doe, trustee of the Jane Doe Living Trust, and then the date that the trust was signed. The possible next step is to locate the trust document, the trust agreement, and determine who is the successor trustee if Jane Doe is now deceased. Now, if the property was individually owned, the deed will say John Doe, or John Doe, a single person, a single man, and then you'll know that that was owned individually. Now, depending on the state where the property is located, probate may be required, as it would be in Massachusetts and New Hampshire, to appoint a personal representative or an executor or an administrator if there's no will, who can sell or transfer the land. Now, if the property was owned as joint tenancy with right to survivorship, on the deed, you'll see language such as Jane Doe and Alice Brown as joint tenants with right to survivorship, or you might see when it's owned between husband and wife, you might see Jane Doe or John Doe and Jane Doe as husband and wife, or you might see John Doe and Jane Doe as joint tenants. So in many states, listing a couple on the deed as being married indicates a default form of joint ownership, often joint tenancy with right to survivorship or tenancy by the entirety, but that varies by states. But we have tenants by the entirety here. So the next step for you would be a probate will probably not be necessary if it was owned this way, if the other co-owner is still living. Now, full ownership of that land or that property automatically passes by law to the surviving joint tenant. So the heirs of the deceased or the beneficiaries of a will or a trust will not inherit any interest in the land as titled. Now, the Registry of Deeds may require an affidavit of surviving joint tenant along with a death certificate. to allow the land to be sold or transferred after the death of the first tenant. Now, another form of ownership is what we call tenancy in common. And you would look on the deed, it would usually say who the owners are. For example, Alice Brown, James Cooper, and Andy Cates as tenants in common, or Alice Brown, James Cooper, and Andy Cates as joint tenants. Now, the family of the deceased tenants in common will probably need to file a probate case in order to have someone appointed to be personal representative or executor or administrator. That way, they will have the ability to sell or transfer the deceased interest in that land or that property according to state law or to the decedent's will. Now, if one of the tenants in common is a trust, probate will likely not be required for the transfer of that interest that the trust owned. Now, another type of ownership that you might see on a deed is what we call tenancy by the entirety. We have that here, where it can only be held between husband and wife. So you might see that sometimes on a deed in Massachusetts. So we have John Doe and Jane Doe, tenants by the entirety, or John Doe and Jane Doe, husband and wife. And in some states, title to the property between a married couple is automatically held by tenants by the entirety. So what about next steps? So like I had stated to you, this option is only available to married couple and in some states. The surviving spouse automatically becomes the full owner of the property upon the death of the other spouse. So no probate will be required. The survivor may need to record a new deed or an affidavit of the surviving tenant before the survivor can sell or otherwise transfer the property. Another way in which you can hold property is community property. So Massachusetts and New Hampshire, we are not a community property state, so you wouldn't see that on a deed located here, but you would see it in property that is held in other states, so or in some specific other states. So we have John Doe and Jane Doe, husband and wife, as community property, or you might see John Doe and Jane Doe, husband and wife, and that would be community property if it was in a community property state, or Jane Doe, a married woman. So the next steps for that is usually the surviving spouse of the deceased will automatically inherit their deceased spouse's interest in the property, unless it was otherwise disposed of by the deceased spouse's will or trust. So probate may not be necessary, but you may need to obtain a court order in order to transfer title to the spouse. So there's some other miscellaneous that you might see. And if you see any of the language that doesn't quite fit the above examples, be aware that there are other forms of ownership, such as life estates and tenancy and partnerships, that may use different wordings and that can lead to a wide variety of legal results. So if you see something like this, or if you just see any of the titled properties that I mentioned above or previously, you just want to contact an attorney or a title company or some other knowledgeable real estate professional so that can help you determine what the next steps would be. Now, after you've determined the type of ownership on the deed, it's a good idea to have the property appraised as soon as possible after the death of a loved one. The appraisal is beneficial for a variety of reasons. First, if you sell the property to a family member or a friend, or even if you choose to purchase the property yourself, a professional appraisal will protect you as the trustee, the personal representative, or the executor, should any of the other heirs or the beneficiaries claim that you sold the property in a self-dealing manner for less than full market value. Now, if you sell to an unrelated third-party purchaser, an appraisal will help you determine whether you're getting a fair price for the real estate and protect you from accepting lowball offers. It will also protect you as the trustee, the personal representative, or the executor from claims that you're not acting in the best interest of the beneficiaries. Now, if your loved one's estate could be subject to estate taxes, an appraisal will help you verify the value of the estate for tax purposes. If you intend to sell the property later, an appraisal will help you determine the new tax basis of the property established upon the death of the previous owner, so you can accurately calculate the capital gain or loss when you ultimately sell the property. Now, documenting the proper value of the property can also help with obtaining insurance sufficient to cover any damage to the property while you are administrating your loved one's estate or the trust. When you are handling the final affairs of a loved one, properly maintaining the property until it's ready to be sold is another important task. For instance, you must determine if the property still has a mortgage against it and whether there are sufficient funds in the estate or the trust to continue making those mortgage payments. If not, you could risk foreclosure, which can exponentially complicate your job. If funds are available, you should ensure that timely payments continue to be made. And in addition to maintaining any mortgage payments, you should also make sure that the property taxes and any other necessary payments, such as water, electricity, gas, yard maintenance, security systems, types of bills like that, make sure that they're timely paid. With respect to phone and the internet and cable bills, you should determine whether those are first necessary. But keep in mind that certain alarm systems require a phone line or internet connection to continue to function properly. Now, once you've listed the property for sale, you must be sure that you know what disclosures about the property that the applicable law and regulations requires. In some states, you're required to disclose a variety of property conditions to potential buyers, and failing to do so can expose you to significant liability and even litigation in some cases. Now, some of the more common disclosures that you should be aware of include the asbestos and mold and water damage or lead, whether there's been mechanical or electrical problems or issues in the past, whether there's any structural problems, if the house is haunted, or if there's any natural deaths or murders or suicides that happened in this home, if there's any boundary disputes with neighbors, if there have been any environmental issues or natural hazards such as radon levels or contaminated soil, and also if there's any drug-related hazards that have been on the property. Now, you want to check with your local real estate agent or attorney to determine what disclosures are actually required under state law. Selling the property of your loved one does not have to be overly complicated. It can often be done very quickly and efficiently. And now that you're armed with the above information, you'll be far better prepared to handle this important aspect of your loved one's final affairs. If you need help, we welcome the opportunity to visit with you and talk to you about your specific needs. So feel free to give us a call. So I want to thank you for watching this, and I'm Kelly Longtin from Kelly Longtin Law, and if we can be of any help, please give us a call. The number's in front of you, 978-566-3500. Thank you.